Now, let's get some legal and political analysis for this particular matter. We're joined by Dr Mkhuseli Vimba. Dr. Vimba, good to have you, and thank you very much for your time. It is a temporary interim victory, so to speak, while, of course, the matter is going to be considered. There's a lot that has been canvassed by, for example, the university itself, in terms of they are saying there's been clear email communication between the premier and the head of the department that was fired, and of course there is also talk of the SIU being overzealous, wanting to I suppose discredit the premier. How would you read these legal documents, and what are they saying in terms of this particular interdict?
Thank you, and thanks to your viewers. The court was very clear today in terms of saying that Mr. Mabuyane has the case in terms of him being investigated. And that is only in respect of the proclamation talking to masters and not to, to honors and not to masters. But I think this is a question of interpretation, because the proclamation is very clear in its interpretation. Though it refers to master, to honors, but it also talks to matters incidental or related or linked to. So, which I believe is the strength of the argument of the SIU to say we are not investigating individuals, we are investigating processes. And out of such investigation, we have identified or discovered that the premier is involved in the maladministration or in the process of maladministration at Fort Hare University. So, in other words, what I'm trying to say is that it's just a question of interpretation, which I believe it will be ventilated when we get to part B of this case.
Yeah, the court seemed to believe that very same phrase, any act must be relevant to, incidental to, matters listed in the schedule, saying that in itself is a limitation, because it only limits the SIU to deal with matters that are listed or that are relevant to what is listed in the schedule, not just any other matter, incidentally, that could be brought in.
Hence, I'm saying that it's an incidental, because on that, hence I'm saying that the incidental matters or matters linked to or related to may, in the view of the SIU, include anything that they come across in the process of investigation. So for me, it would probably mean that the issue of masters, if they are included, or there is a trail of evidence which leads to or which is linked to maladministration that led to him registering masters, then it's an issue of investigation. I think that's the stance of the SIU, to say we were investigating the process, and in the process this is what I found. But the judge was very clear to say that in view of the fact that the proclamation talks about honors and not masters, therefore that deeming provision to say it would also include matters incidental or linked to, then is taken away. But having said that, the issue in question is whether matters incidental or linked to or related to would include masters. In this case, the court says it doesn't. Therefore, the SIU should be interdicted from investigating the premier.
So let's look at part B for a little bit. I mean, there the premier is saying, one, the court should interrogate the decision to issue the proclamation by the president, but two, the proclamation itself must be looked at and be declared unlawful and invalid, and the proclamation be set aside. Never mind the SIU's investigation, but the proclamation itself. What would need to be satisfied there for the proclamation indeed to be, one, the decision to issue the proclamation, and the proclamation itself to be unlawful?
I don't think that is permissible. In fact, the issue of investigation, even interdicting the investigation itself, for me, it's a cause of concern, especially from a person who is holding a serious or a senior political position in the province, because the issue of accountability should be there. So if we take away the proclamation, how are we going to investigate these matters relating to this maladministration? It can only by way of investigation. So I think we cannot suppress the issue or suppress investigation or say that certain people cannot be investigated because there is an issue, there is an element of accountability, and the public need to know what exactly happened. Has he written his dissertation? Was he assisted? And those questions have not been answered. And we are hoping that those will be the critical questions that need to be answered when we get to Part B. So in my view, the issue of setting aside the proclamation, especially after uncovering such evidence, remember that he is not the only one who is cited or who is investigated. That would wash away all the investigation that has been conducted by the SIU so far. So I don't think that it will be the way to go, or that they will succeed in setting it aside.
How much weight does the forensic report hold here in terms of the motivation for the president to issue the proclamation?
Yes, the SIU, in terms of the process, is the one that prepared the document to the president, asking the president to issue the proclamation, and on the basis of that, the president issued the proclamation. And it is for that reason that there is a thinking that the SIU may go back to the president to say, please, can you allow us to amend this proclamation to include this? Which I believe then it would also be a way to go in terms of ensuring that all the maladministration at the university is uncovered and people who are responsible are account for it.